Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lathan.
Your Honor, I did attempt.
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade Ruth Ann Lathan and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe.
All right, this is a huge legal moment that can fly under the radar. When a defense attorney raises competency, everything changes. The question stops being, did she do it, and becomes, does she understand what's happening in court? Judges take this seriously because the system can't move forward if the defendant isn't legally competent. And notice the tension: identity arguments on one side, courtroom procedure on the other. What do you think? Strategy or genuine misunderstanding?
We'll reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the cardholder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for 90.
June 6th at 9 a.m.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case, People versus Jade Lathan.
Mr. Canopy for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. Bond continued. Yeah.
Thank you, Your Honor.
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lathan, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker 15400 and AA Condolis 02002 claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I disturbed the peace, and I have on file with the public defender, Kenneth Overwater, right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth. And I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied two main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These two things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that
Okay, pause right here, because this is where viewers usually go, wait, what is happening? The language you're hearing comes from belief systems sometimes associated with sovereign citizen or self-declared jurisdiction arguments. Here's the key legal reality. Courts don't operate on personal definitions of identity. They operate on statutory law. So while she clearly believes these arguments matter, the judge is listening for legally recognizable motions, and they're just not matching up. Honest question for the audience, should courts spend more time explaining this, or is it the defendant's responsibility to adapt?
since the date of March 7, 2024, and I yield.
All right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
And if I-